statement prior to convening the meeting. Today is a significant day for Essex Regional Retirement Board. The decision by Judge Murtaugh last Thursday to allow me to be seated as chairman and the vote taken by the board to terminate Mr. Bassett from the position of executive director 2 weeks ago represents significant changes for Errb. For those who have worked diligently to bring about this change, I applaud you. However, this is in no way the end of the road. Much about how the board operates needs to change before the public trust can begin to be restored. Even then, the ongoing work of PERAC and other agencies may result in the kinds of punitive actions that will stain the reputation of the board for many months or even years to come. In addition, highly regarded legislators like Senator Tarr, Senator Berry, Senator McGee are working diligently on legislation that will not only require the oversight of a PERAC-appointed receiver, but also ensure that no board will ever be able to find itself in the position we found ourselves in today. During my tenure as chairman, I promise that this board will be hardworking stewards for the retirees and future retirees we represent, and a transparent agency willing to answer the difficult questions from those whose precious taxpayer dollars fund us. On any particular issue, you may not like what we decide, but you will not question the process that led to that decision. To those people who work for the board, I can only imagine how difficult all of this has been on you. I wish I could tell you today that when you return to work, that there will be no more newspaper articles or people raising questions about your work ethic or integrity. I can simply not make that promise. The errors of the past mean that the expectation for the future will be higher for you than your peers serving in other retirement systems. However, if you join me in striving to be the best-run retirement system in the state, I promise you my unwavering support, a work environment that will be the envy of others, and the resources necessary to excel at what you do. To my fellow board members, you will notice as today progresses that I'll be promoting an agenda of dramatic change to the way the board has conducted its business. Peter Drucker said, "The greatest danger in times of turbulence is not the turbulence. It's to act with yesterday's logic." Clearly, the methods of the past have led this board to a place that is not just unacceptable, but a place that we need to move forward from today. Join me in demonstrating the leadership necessary to change the way the board has conducted its business. Get past whether we feel offended or hurt by what has been said or printed, whether you support it or not. Today we can lay the foundation for the future. Join me in making that a reality. Now I'd like to convene the Essex Regional Retirement Board meeting for April 12th at 9:05. What I'd like to do first, everybody has a copy of the agenda. Since I've been appointed more recently, I haven't had an opportunity to understand completely how the agenda was put together, and I'm sure we'll discuss that as the meeting goes on, or the particular relevance to any item on that agenda. I can say I've added item 5, which is new and old business, so that we can talk about topics that may not have been specifically spoken about or discussed prior to the construction of the agenda before my appointment on April 7th. I would say that I think it's important, so bear with me as I sort of bounce around this agenda a little bit, and I focus on item 4, report from outside counsel concerning pending litigation, and I'll not make reference to the vote concerning the possibility of executive session. But under that topic, what I'd like to see the board do first is have a discussion relative to what I see as pending litigation, and that's the decision by Judge Murtaugh to appoint me as chairman and the decision of the board on whether or not to pursue an appeal. Since I have a financial interest, i.e. my stipend, relative to the decision of how the board proceeds, I'm going to recuse myself while the board has a discussion on whether or not to appeal that decision. I also will step down as chair, which is appropriate in these cases. I'll ask Mr. Montenot if he could for this particular discussion to serve as chair, if that's okay. And I'll now recuse myself.
So we'll take Article 4 out of order?
Sure.
Okay. The Essex Regional Retirement Board will move to item 4, report from outside counsel concerning pending litigation and discussion of strategic litigation issues.
Mr. Chairman, if we could at this time, would someone please make a vote to go to executive session?
I'll make that motion that we go to executive session.
I have a motion to go to executive session. Is there a second?
If there's no second, Mr. Chairman, I'm not sure that the outside counsel will be able to tell us exactly what's going on. I'm sorry to say.
Well, we can, as the chairman that stepped down mentioned, this is for discussion purposes only, and we can discuss the issue. If we have issues that are impersonal in nature, we can convene into executive session. But I think right now, just opening it up to discussion is the order of business.
I would like, if you could then ask the legal counsel, they must be sitting there,
Yes.
if you could ask them if we would lose our right to have them be our attorneys and not, I forget what you call it, I'm sorry to say.
I think the question is there an attorney-client privilege issue?
Right,
which
that's
I'll,
my question. Thank you.
I'll let Attorney Durant address.
Ms. O'Leary, surely anytime there's communication between council and the board, those communications are privileged. It is the board's privilege, and the board can choose to waive that privilege and have a public discussion. I think what you were raising earlier is a request for a motion to go into executive session, and a valid basis to go into executive session were to be to discuss strategic issues affecting the pending litigation.
I thought what we were going to discuss, I'm sorry if I was wrong.
Well, no, we were going to give a report that when we prepared this agenda, that report was different than it is today. We are happy to give a report based on the public opinion of Judge Murtaugh, and we can certainly outline for the board the options that are available to the board in terms of going forward. If the board would like to then have a discussion and make a decision about what options it chooses to pursue, you can either choose to have that discussion in the public session, or with a majority vote of the board, you can choose to go into executive session to discuss the strategy concerning that litigation.
All right, thank you very much.
Sure.
Point of order, any votes coming out of that executive session would need to be made in public session.
Correct.
Absolutely.
Okay.
Wait, yes. Michael Calora for Dwyer and Calora. We're outside counsel to the board for certain matters. At the request and vote of the board, we commenced litigation in Middlesex County against PERAC, the Public Employee Retirement Administration Commission, because at the time of the litigation it had indicated it would vote to appoint a first member or chairman because the board had not timely acted within 30 days of the expiration of Mr. Bassett's term, who had been the prior first member or chairman. We had given legal advice to the board that we believed there was a valid cause of action on behalf of the board to allow it to continue so long as PERAC had not acted to replace its chairman with its own choice. We commenced that litigation in late February. We secured from the Superior Court a temporary order, which was not contested by PERAC, that pending the decision by the court, PERAC would not act to appoint a chairman. It could take all of the steps up to that point, which it did. The court then ruled on April 7th. We got a copy at the end of I think April 9th, actually. It was mailed out on the 8th. But in any event, and so before the agenda was sent out, but after we had gotten, the agenda had been sent out and we got the decision after. Judge Murtaugh disagreed with our reasoning and permitted PERAC to go ahead and appoint the first member. Now this is a action on a preliminary injunction. The board has options at this point. One is to accept the decision, in which case it now, or perhaps at its next meeting, should instruct us to dismiss the case. I'm sure that PERAC would agree with that decision and there would be no further action by the court. The other option is to appeal. You can appeal either the action by the judge now from the preliminary injunction, or you can ask the court to